Wine Industry Network's 2024 Bold Prediction Series is presented by Heffernan Insurance Brokers, with supporting sponsors Protea Financial, Turntine Brokerage, and American Ag Credit. Thank you for your support.
Hi, Liz Bishop
and Deborah Costa
here from Heffernan Insurance Brokers, and we are your fire mitigation and insurance
gurus.
This wildfire structure protection unit is a unit that the British Columbia government has been utilizing for about 10 years. And in 2023, there were 500 structures that were saved by this unit. So it has proof of concept.
Here today, we have Adam Iveson from Ember Defense to share with you a few important notes about this structure.
So this is a structure protection unit. This has everything on board to be self-sufficient. This has pumps, sprinklers, hose lays, bladders, everything to be off the grid to protect your property ahead of an oncoming wildfire.
Liz and I, in partnership with Ember Defense, are committed to protecting your winery property. Just think, if everyone invested in a wildfire protection unit, together we could ensure that wineries don't burn and make insurance affordable again. Text WASP Demo to 707-789-3062 for a free demo on your property.
Hey everyone, George Christie again with Wine Industry Network. Welcome to another episode in our Bold Predictions webinar titled New Regulations Impacting the Wine Industry. This session is going to be focused on the bottle bill and addressing some of those questions that I know many of you have. We're really fortunate. We've got Tim Schmelzer here, Vice President of California State Relations with the Wine Institute, to present on the bottle bill. He's very well versed in this, and certainly take advantage of the fact that we've got Tim here. Now, as is always the case, we pre-record these sessions. We do that for quality purposes, but the good news is Tim is watching this broadcast right along with you. So as you have questions, go ahead and submit those to the chat room or via the chat feature, and Tim can pick those off as they come in. So you don't need to wait till the end of the presentation to fire off those questions. Okay, well, before we get started, I want to thank our sponsors, Heffernan Insurance Brokers, who is our presenting series sponsor this year. Thank you for all your support. Along with our supporting series sponsors, we've got Protea Financial, Turntine Wine Brokerage, and American Ag Credit. All right, once again, thank you for taking the time to be with us. Why don't we get started? Tim, why don't you take it away?
All right, thanks a lot for the introduction, George. So again, I'm Tim Schmelzer, Vice President of California State Relations for Wine Institute. And I was a chief lobbyist, and still am, for Wine Institute when the bottle bill law went into place. So I've been lucky or unlucky, as some may see it, to have been right in the middle of this from the drop. I want to begin talking about a little bit how we got here. Wine Institute's members have long been looking for a way to better ensure that wine containers get recycled, and have analyzed a number of possible schemes that may work for us. And we ultimately concluded after surveying the landscape and engaging in some pretty heavy research that the California's bottle bill program was going to serve our members' interests best in the state of California. We feel that this program is both best for our membership and the wine industry at large, as well as wine customers. With that having reached a conclusion, we then decided to support legislation to bring wine and spirits into the bottle bill. This reached its conclusion in 2022 when Senate Bill 1013, sponsored by then Senate Pro Tempore Tony Atkins, was signed into law. We had a number of provisions to accommodate the unique aspects of the wine industry put into that bill. And among the most important ones is to give ourselves a little bit of time so that even though it was signed in 2022, it wouldn't go into effect until January 1st, 2024. This bought us some time to be able to take a close look at what potentially some of the unintended consequences might be, and really evaluate and make any tweaks to the program that we thought might be necessary during the next legislative session. Indeed, we identified several of these. probably one of the most important ones I'll get to later was to ensure that wineries didn't have to go back and relabel wines that they had already labeled and had in storage. This cleanup legislation was in the form of Senate Bill 353, sponsored by Senator Dodd from Napa, and that got signed into 2023 and became effective along with SB 1013 on January 1st, 2024. So January 1st, 2024 is the date at which wine and spirits containers become subject to that law. This is true even though the labeling requirements don't kick in quite at that time. So regardless of whether a wine or spirit bottle is labeled, they are part of the program beginning in January 1st, 2024. The program applies to all beverages that are sold for consumption in California. So this notably doesn't apply to exports or any products sent for consumption out of state. One interesting fact I wanted to share with you all, the wine industry, which my latest count is we have over 6,000 wine grower licensees in the state of California, plus the distilled spirits community together serve to increase the participants in the bottle bill program by over 300%. So CalRecycle, who's the state agency that administers this program, suddenly had to register a huge number of participants that really dwarfed the size of the program prior to January 1st, 2024. So the reason I'm saying that is I'm sure there's many watching who have submitted registrations that still haven't had them processed by CalRecycle. Just want you to note that they are fully admitting that there's a backlog and they're trying their best to catch up. So I'm going to move along now to the actual provisions that you all need to worry about for compliance purposes. The first thing I wanted to talk about is the bottle deposits. We refer to this in California shorthand as CRV, which means California Redemption Value. This is the amount that ultimately the customer pays at the register and then can get redeemed at a recycling center when they turn their empty container in. The rates for those are 10 cents for containers 750 milliliters and larger, and 5 cents for those below. That actual threshold is 24 ounces, but practically speaking in the wine industry, that means your 750 milliliter bottles are 10 cents, and those below that threshold are 5 cents. One of the important provisions that we insisted on when we passed the original legislation is that all wine container types would be entered into the program, not just bottles and cans and PET. So bag and box and Tetra cartons are also now part of the program if they contain wine or spirits. However, the CRV for those ones are 25 cents. And unfortunately, this is regardless of size. This is something that we're actively pursuing a change on in the legislature this year, so you're aware. The redemption fees need to be paid by what the bottle bill program considers the distributors, which in this case is often a winery, and I'll explain. The redemption fees get paid directly to CalRecycle by the distributors, less a 1.5% administrative fee. Wineries are considered distributors under the bottle bill program when they sell or donate directly to a consumer or a retail licensee. Any case in which you're bypassing your wholesaler, you are considered a distributor, and therefore you're responsible for paying redemption fees to CalRecycle. It is expected that you will recover those redemption fees from the customer that you are selling to. So if you've ever been to a store and bought, beer or soda, you'll notice that you're being charged 10 cents for every container that was subject to the bottle bill. It is expected that a distributor, when they're selling their products to the end use customer, that they are doing the same. So that is meant to be a recoverable cost for you all. Interesting exception that we were able to get for ourselves. Bottles that are poured in a tasting room at your licensed premises for on-site consumption are exempt from the redemption fees. And this is simply for the fact that the customer doesn't walk away with a bottle in that instance. So the way the law reads, this is both bottles used for tasting, and if you happen to have a premises that allows people to enjoy a glass or bottle of wine on your premises before leaving, those bottles are also exempt from the redemption fee. Now I'll move on to the less well-known processing fee. The processing fee is owed by all those considered manufacturers under the bottle bill law. Wineries are clearly manufacturers in this instance, and as a result, they are responsible for paying to CalRecycle a processing fee in addition to any redemption fee that they may or may not be having to pay. This processing fee is meant to offset the actual costs of recycling. This amount is computed on an annual basis based on real world data. Right now, unfortunately, glass, for example, isn't totally economically recyclable, and as a result, there is a processing fee associated with it. Notably, aluminum is considered very economically recyclable in the state, and there is no processing fee associated with aluminum. Once again, just want to note, this applies only to those containers that are sold for consumption in California. The current rate for glass is, you'll note this is very much lower than the redemption fee, is just a little over half a cent per bottle. It amounts to about 6.9 cents per 12 bottle case. The processing fee varies based on container type. So there's, like I said, there's no fee whatsoever for aluminum. There's a separate fee for glass. There's a separate fee for the new container types we brought into the program. There's a separate fee for PET that gets brought into the program. The new container types, since they haven't yet had this real world evaluation of being in the bottle bill, through the year 2025 are going to be set at a rate that's, as you can see here, just about 0.7 of a cent per container. Note that a winery is considered a manufacturer regardless of who the bottler is, even if the winery actually sells the products. I bring that up because there's a very confusing definition of manufacturer in the law, because the law was originally put in place back in the 80s, where soda was the dominant beverage and bottlers were essentially the manufacturers. We had to clarify that for our industry. So much of our industry, as you well know, uses a third-party bottler. We clarified the law last year as part of the cleanup to ensure that it was very clear that wineries were considered the manufacturer even when they used a third-party bottler, so long as the wineries were still responsible for the sales of the wine. Note that a winery who actually makes the wine is considered the manufacturer in custom crush arrangements. This can create a bit of a confusing circumstance because just because you're making wine for someone doesn't necessarily mean that you are aware of your sales. You will need to make arrangements with your clients in these circumstances. They can either report that information to you and agree to pay you for the fees owed to CalRecycle, or some folks have found that it's in their best interest to sign a pay on behalf agreement between the manufacturer and your client, where the client would then be the entity that directly interacts with CalRecycle to pay these fees. In the instance that those forms are signed, they need to be filed with CalRecycle, so CalRecycle is aware of who they need to be dealing with in the collection of these fees. Next, I want to talk about labeling, which is a bit confusing. So bear with me, and I'm going to do my best to explain this. The labeling requirements do not kick in. And by labeling, I mean labeling, having the CRV indicia indicated on your labels. So where it either says California redemption value, what most people use is CACRV. You'll see that on the examples I have here on the screen. That is not required until July 1st, 2025. However, we all know wine is made well ahead of time, and there are provisions in the law to account for this. The most important one is that any wine bottled prior to the implementation of this law, prior to January 1st, 2024, so if they're bottled and labeled, they are exempt for all time from needing to put that California redemption value labeling on. However, any wine made after that date will be expected to have that indicia if that wine is sold on July 1st, 2025 or thereafter. And this is very important to note because without this indicia on your product that was filled and labeled after January 1st, 2024, those products could be pulled from the shelves potentially. There are several messaging options that I referred to. The longest one says California redemption value, since wineries take great care to make sure their labels look nice. Almost everybody is choosing to use the smallest of the possible messaging options, which is the CACRV. Again, you'll see some examples here on the screen of how those go. There's some very specific requirements about the font size. For example, it needs to be at least 3/16 of an inch or slightly smaller if you use a contrasting color, and you'll see on these examples where the contrasting color is slightly smaller than the example of where it's in the same color. We secured a provision such that wineries are not required to go to CalRecycle for pre-approval before they have their labels printed. We did this mainly because we didn't want to overwhelm CalRecycle, and we were concerned that your products could get held up since there would be thousands upon thousands of labels that they would need to approve. However, they have been more than willing to make themselves available if you have questions for them. And certainly feel free to reach out to me if you'd like me to help you with ensuring that you have a properly labeled California redemption value label. Notably, the law also allows for a QR code in lieu of this redemption value indicia. However, the regulations to implement that are currently ongoing. We're participating in that. We are hopeful at Wine Institute that we can ultimately replace the California redemption value indicia requirement with a QR code. And moreover, that this QR code could be used to meet other regulatory requirements we see around the state and frankly the world regarding things, other states' recycling requirements or even nutritional labeling requirements. So that's an ongoing effort there. Might have wanted to start with this, but I wanted to make sure you had all the information first. It is important, to say the least, that all wineries register with CalRecycle. Almost every winery, unless it so happens you have zero direct sales, will need to register as both a manufacturer and a distributor. When you submit that registration to CalRecycle, CalRecycle is then required to get back to you. They will give you your codes that identify you as both a manufacturer and distributor, along with instructions on how to file reports on your monthly sales and pay your fees, which can be paid online. It is notable that CalRecycle's got quite a backlog at this point, so it's important that you keep track of your data if CalRecycle has not yet responded to your registration. And by all means, if you have not registered yet, it is absolutely critical that you do. Failure to register could subject you to penalties potentially. And lastly, I want to say with regard to labeling, you should absolutely, any product that's coming, that's being bottled and labeled right now, should absolutely have that redemption value indicia on it. At this point in time, it would be difficult, I think, for you all to predict whether that wine is likely to still be for sale after the July 1st, 2025 deadline to have that indicia. So we recommend strongly that you all get that labeled right away. And I just wanted to, as a final note, go over some of the other provisions that exist in the bill. Most interestingly, I think there is an exemption from the monthly reporting and fee payment to an annual reporting and payment period for any beverage manufacturer that has a processing payments of $15,000 or less a year. Extrapolating that into the wine world, essentially any winery that is producing less than 300,000 cases annually is eligible for annual payments instead of monthly. This is a huge bureaucratic relief to you. Unfortunately, CalRecycle right now is insisting that wineries of all sizes show a track record of compliance through 12 months before they allow annual reporting. We are engaging with CalRecycle to try to get them to shorten up that date to provide you all some bureaucratic relief on that front. Also, just anticipating a question, wineries are not required to redeem used containers. You can if you want, but by no means are you required to accept used containers at your winery. And finally, one of the biggest issues that exist within the bottle bill program is the fact that there aren't a sufficient number of recycling centers. There were provisions in both SB 1013 and in the follow-up legislation SB 353 that directly attacked this problem, and we are hopeful that we're going to begin seeing more and more recycling centers around the state. There's been a dramatic reduction in the number of those centers in the last 5 years, and we're certainly hoping to increase those numbers so that our customers have every reasonable opportunity they can to redeem the deposits which they pay. Also, with the influx of wine into the program, this will obviously dramatically increase the amount of glass in the program. We are able to secure some of the CalRecycle's existing funding to put towards making glass recycling more economic. So we're hoping that that ultimately yields in lower processing fees for glass. And that is all I have for you at this point. I want to thank you all for listening, and I am happy to try to address as many questions as I'm capable of. I also, as a final note, want to recommend that you visit Wine Institute's website. I have it listed here. We have a public-facing page that puts all of this information in one nice, convenient place, which is, we hope, much easier than trying to navigate the fairly unwieldy CalRecycle website. So we hope you take advantage of that. Thank you very much.
Well, Tim, thanks so much. That was great. Very informative. I know that there are still a lot of questions out there. So appreciate you being with us today. I want to thank everyone in our audience for being with us. And of course, thank our sponsors once again for all of their support.